So the next question we need to discuss is the question of who can make a contract. And this is a really important question because even though we might have all of the elements of a contract, unless all of the parties to it can in fact have capacity to make that contract. So capacity is the term we use, and it really refers to the ability to make a contract. Unless all of the parties have that capacity to contract, it's very difficult to sue those parties or to enforce the contract against them, even though we might have a contract that is valid for common law or other purposes, and it may in fact be enforceable against the parties who have capacity. So in order to work out who has capacity, we need to identify who has legal personality. So there are two categories of people with legal personality: natural persons and legal persons. So natural persons, no surprise, they're human beings, where legal persons are corporations or other entities or bodies corporate that the law recognizes as having legal personality. So the term legal personality refers to the capacity to have rights, protections, privileges, responsibilities, and ultimately legal liability. The ability to sue or to be sued is a better way to think about it. To be sued on a contract requires you to have that legal capacity. So let's break that down into the natural persons and the legal persons. So natural person is a human being that has the capacity to act as a legal entity. Now, not all human beings have that capacity. We separate humans into those with legal capacity and those without. Now, you might be aware there's been a reasonable amount of press and discussion over recent times, months and years even, about what the age of criminal responsibility should be. And in many places, many social workers and people with similar political opinions to my own think that the age for legal capacity, for criminal capacity, is set too low. And as a consequence, we're ending up with very small children, so 10-year-olds, incarcerated for crimes. In relation to voting, there are, I think, some very good arguments for lowering the voting age. At the moment, a person doesn't have the legal capacity required to vote until they're 18 years of age in Australia. And I think there are many good arguments for lowering that to 16 or possibly even younger. In relation to contracting, again, it's a state-by-state basis and also internationally. But in Australia, each of the states has set the capacity to contract basically at the age of 18. Now, you might be thinking, but I've been entering into contracts every day since well before that. Yeah, but have you been sued in relation to them? Now, there's some quite complex and actually, frankly, very old common law on the question of when a minor can be sued on a contract. Minor here spelled O-R, not E-R. I'm not talking about the people with the hard hats. I'm talking about people under the age of 18. For our purposes, we don't need to get stuck into it. I'm very happy to answer questions about it if you have them. But the question is rarely whether that person can enjoy or not enjoy the benefits of a contract. It's whether or not they had capacity to enter into the contract at all. And usually the circumstances in which they will argue that they didn't have capacity are relatively limited. And of course there are exceptions. So for example, under the common law, an exception includes that the items that were being purchased were necessaries. And in this context, it's for the person's station in life. Also, if the goods themselves have actually been consumed or used, you can't undo the contract. You need to put everybody back to the place that they would have been otherwise. But anyway, we can address that if we need to. For our purposes, it's important that you understand that that cutoff age is 18, and that if you as a company, acting for a company, are contracting with people under the age of 18, that unless certain exceptions apply, you may actually have difficulty enforcing those contracts in the future if you're asking those people to do something in the future. In relation to legal persons, clearly the most obvious of these is a company. So companies have legal capacity essentially from incorporation. In fact, there are elements of the Corporations Act that provide that contracts that are made in contemplation of incorporation will in fact be binding on the company. So technically, a company can have capacity before it even exists. Other kinds of organisations that have capacity to enter into contracts include government organisations, not-for-profit organisations, so registered charities and other entities. In some jurisdictions, believe it or not, animals and environmental entities like rivers or forests can have capacity to contract. Remember early on in one of the discussions we talked about Yahoo. A large part of the argument in that particular case related to whether the laws of France could be applied to a US legal person. So these kind of issues come up all the time, and as a general rule, companies have capacity to contract. But unlike a natural person, a legal person that is a legal entity can't do anything unless a human acts for them. So they act through agents. So, for instance, a corporation can enter into contracts, but it does so through its agents, which could be directors or employees, but actually these days can also be technologies. How often have you entered into a contract online where essentially there's been a process where you have filled in a form, you've accepted the terms and conditions that have been offered to you, and then your parcel arrives in the mail a few days later? That is a contract. A contract has been made. The consideration is your agreement to the terms and conditions and your payment of the purchase price, and the vendor online has basically enacted what's happening on the form and sent you the goods. As you probably noticed these days, it may be that no human hands ever touch those goods, that the whole process is driven by technology, incorporating AI and other technologies. How do companies sign contracts? Take a look at the Corporations Act, sections 124 through to 127 are the relevant provisions, and they set out where a company's power to make, vary, ratify, or discharge contracts, and that those activities can be exercised by individuals acting within the company's express or implied authority on behalf of the company. Forgot that I had a slide basically talking about all of the things that I just spoke about. Hopefully you flipped ahead when I didn't in the lecture. So let's now focus on the extent to which capacity to contract in a digital context creates any kind of issues. So digital contracts can pose challenges in determining capacity and legal personality. In particular, it is very difficult to determine whether or not you are contracting with somebody who has capacity to contract when you're in an online environment. So actually knowing whether or not you're dealing with a child or somebody who's suffering from some other kind of incapacity, I'll get to them in a minute, but other incapacities can include being drunk, being under the influence of drugs, suffering from a mental illness, or a range of things that impact decision-making capacity at the end of the day. Particularly when an AI is dealing with somebody online, its ability to detect whether or not somebody has capacity or not is limited. But let's face it, so is our ability online, whether we're using artificial intelligence or whether we're just using some kind of form. So in a traditional contracting environment, it was a little easier to tell, right? If you're dealing with somebody and they look drunk or incapacitated, you're in a position where your alarm bells can go off and you can think, okay, they may not be bound to keep the promises that they make here. Or if you're dealing with a small child, you're pretty clearly able to identify that there might be some kind of incapacity there. There's a common sense barrier. But when we're dealing with online forms or online kinds of artificial intelligence, there could be significantly more uncertainty. Similarly, when we're looking at blockchain technologies, where pseudonymity is basically part of the game, where we don't actually know we can't necessarily see without tracing back in some way who the players are, we can end up dealing with anonymous parties who are minors, or in fact might be another AI system itself, and neither of those have capacity to make promises in the future, and the uncertainty itself can lead to disputes about the validity of the contract itself. There are a number of challenges here, and smart contracts in particular can raise some of these challenges. I'm going to talk separately about smart contracts as we move forward and argue that maybe they're not contracts at all, and maybe that's okay. But until we get there, let's just think about this as smart contracts as being technology-enabled processes that execute automatically when certain conditions are met. So if a smart contract is executed anonymously or pseudonymously, that's so hard to say, to an address on a blockchain, identifying the legal personalities behind the contract itself could be really challenging. So it's important to think about these traditional legal concepts like legal personality in the digital age, and then actually pull back and think, actually, when am I really using a contract, and does this matter in the circumstances of the particular transaction that I'm dealing with? And am I using the contract to manage my risks or to hold somebody to account to do something? And now with the knowledge that we need both privity of contract and capacity, I need to make sure that as a company that the contracting party is in fact somebody who has that capacity, and in most cases is somebody that I can identify so that I can sue them if they don't do the thing that they said they were going to do, or so that I know who I'm at risk of suit from if I don't deliver or the company doesn't deliver under the promises that it makes. The issue here is usually when a party doesn't have capacity to contract, then the contract itself will be void as against that party. Now, this can be quite complex. Students who are studying law will often spend up to a week in a module looking at capacity and all of the various combinations and permutations. We don't have the time, and I suspect you don't have the interest for that here. Just want to highlight a couple of things. The common law is complex, but in the state of Victoria, it's largely been codified and pulled together in Section 49 of the Supreme Court Act, so which is essentially part of the legislation that deals with what kind of evidence can be brought before a court. And so ultimately it says that contracts with minors, so children who do not have the capacity to contract, that relate to the repayment of a loan, for the payment of goods that are not necessary, so not things that they need, things that they don't necessarily need, and accounts stated. So if they actually state that, yes, they do owe that money, all of that is treated as void. And Section 51 renders void any promises that a person makes when they skip over from being 17 to 18 to repay those loans that they entered into as a 17-year-old. Now, you might be thinking, I borrowed some money from my folks when I was a little bit younger. They can't sue me on that. Look, we've spoken about this before, chances are when it came to intention to enter legal relations, they had no intention of ever suing you anyway. And frankly, it's bad form not to pay your parents back. Do it. Bank of Mum and Dad needs a holiday. So property and goods passes to a minor under a void contract. So in other words, it's only void against the minor. So if you are selling things online and you are accepting payment later, but you've delivered the goods or services, and unless if they are necessaries, then the minor's going to have to make good on that promise to pay. But if they're not necessaries, you've just sent them a robot dog. Let's use the robot dog. Everybody wants one, but nobody needs one. Then basically that's a you problem or a company problem. It's not the minor's problem. And the minor can argue that even though it promised to pay for that robot dog in the future, because it's not a necessary and because they are a minor, they don't need to do so. Now, clearly, risk mitigation could be, okay, we don't deal with minors at all. But another way is, actually, we get payment up front before we deliver the goods. And then if we have that payment, it doesn't matter that wasn't enforceable because the contract, all of the parties' obligations have in fact been satisfied. So a couple of things looking at the provision. It's worth remembering that the contracts won't necessarily be unenforceable in their entirety. So they're not usually in the usual sense. They're void as against the one party. The provisions deal with debts as well. I've spoken a little bit about necessaries, but for those of you who are interested, you need to go to the Goods Act and then to the common law to really understand this term in any depth. Section 50 here is the one that deals with ratification. Worth remembering that here we talk about minors and majority. It's frankly unnecessarily complex terminology. Just think about it as 18s and under 18s. So now let's talk about what it means if a contract ends up being void as a consequence of incapacity. Now, again, this can be complex. It's rare, but it's one of those things that you need to be aware of. And one of the reasons it's rare is because businesses are good at putting mitigation strategies in place to make sure it doesn't happen. So as a general rule, a void contract will usually have no legal effect. That is as against the party who's lacking incapacity. The party lacking incapacity, or their guardians or supervisors or whatever you like to call them, may well have capacity to sue the company that did have capacity to enter into the contracts. It's worth noting that contracts with minors that are declared void by legislation may be treated differently. Commonly, it's basically a common view that contracts that are declared void by legislation should be treated in the same way as contracts that are binding or not binding unless they're ratified. So the question then becomes what kind of ratification or support is given to ensure that contract continues to be binding. So let me give you an example. A contract could be enforced by a minor. The property and the goods could pass to a minor by virtue of delivery, but if the goods aren't necessities or necessaries, then the minor may not be required to pay for them. Where a loan to a minor is rendered void, then any guarantee that's given for that loan will also not be enforceable as a matter of common law. Why? Because the purpose of a guarantee is to guarantee that the person having the benefit of that guarantee will be in the same place as they would have been in if the other party had met their obligations under the contract. But in this particular case, the other party doesn't need to maintain or meet any obligations under the contract because the contract is void against them. So there is no obligation under the guarantee. However, if instead of a guarantee, the lender or any person who's seeking some sort of third-party support for a minor's promise, if they give an indemnity, which basically is a promise that holds the beneficiary of that indemnity harmless against the situation as if the contract had never happened in the first place, then it's quite likely that they would need to be repaid, because even though the contract is void, the lender or the person delivering the goods is out of pocket. It's actually quite a difficult concept to explain, hence me tripping over my words a little bit here, but it's also something that doesn't happen very often. And as I mentioned before, many companies are really good at mitigating for these risks by seeking age verification in some way, seeking indemnities from a person who is authorized to give them, requiring credit card or other payments, and relying on banks, etc., to not issue credit cards to people who don't have capacity to use them, or then seeking payment from a parent or guardian, or seeking indemnities from parents or guardians. But above all, actually seeking payment prior to the delivery of the goods mitigates that risk significantly, because it's not an ongoing contract then, that everything is completed before this issue arises. And provided that there isn't fraudulent behaviour or misleading or deceptive conduct, it is quite rare to see these kind of contracts undone. Questions, concerns, frustrations, compliments? If you've got a better way of explaining this, please share with me. Cheers.